No man is an island, especially when it comes to court. It takes several to tango. When you are taking pretrial action against your opponent, they must be notified. After all, if only one softball team shows up for a game, it's not really a game, is it? This notification is called a notice of hearing. It is a legally required document that tells all parties when and where the judge will hold a hearing on a motion. A motion is basically when someone asks the judge to make a ruling on an issue. Either party can make a motion, and if they want to present an argument to persuade the judge to rule on that motion in their favor, they need to set it for hearing and send the required notice. A notice of hearing must contain the basic information of the hearing, specifically when and where it is, who will be holding the hearing, such as a judge or magistrate, and what motion is going to be argued. The notice itself, like any document submitted to court, should be perfectly legible, specifically typewritten in black ink. Instead of that hot pink glitter marker you prefer to use. Once the document is complete, the original should be filed with the court clerk, while keeping a copy for your own records. It is your responsibility that the opposing party receives this notice, or that you made every reasonable attempt to get it to them. This means sending it by email or physical mail, depending on how your opponent has elected to receive notices, or having it hand-delivered. If your opponent has an attorney, you should deliver the notice to the attorney, even if a default has been entered, because the opponent didn't show up, for example. A notice still must be sent to them, letting them know of a final hearing. You should try to make a reasonable attempt to find a date and time that works for both you and your opponent. Plus, it should be during hours which the court is actually open and when the judge is available. And different circuits might have additional procedural requirements before setting a hearing. Contact the court clerk's office or the court's website for your particular circuit's conditions. And for help, advice, or information on this and other legal issues, Legal U is always there. Legal U. You can do this.